Welcome to Advocacy Exchange, Navigating Texas Injury Law.
Welcome back to Advocacy Exchange, Navigating Texas Injury Law with Paul Littleton. Paul is the Director of Business Development and Operations at Littleton Law Firm, where he helps guide strategy, client communication, and case management across the firm. I'm Lisa Mosbey, your host, and today we're talking about what it means when an insurance company reaches or keeps reaching out after an accident and how those early conversations can shape the direction of a claim. Welcome, Paul. Thanks for joining me again.
Thank you, Lisa. I appreciate you.
Paul, why do insurance companies sometimes call people over and over again after they're involved in an accident?
Well, I can tell you they like to claim that they're being efficient, taking care of their insureds or any prospective claims that might be against their insureds, or even your own insurance company. But typically what they like to do, because they understand that reciting the facts of something as quickly or close to the incident as you can get it, typically people will offer their testimony, but it's kind of conjungled with their actual opinion of things. Maybe some things aren't exactly factual, but they're just kind of drawing a line of what they think may have happened. And the closer you get to the incident, the stronger that opinion usually is if you haven't had time to go through and just kind of break it down. But when they do that, that's when they get the bits of information that help them deny coverage or potentially place the other portion, at fault to some extent. And then that can kind of deter the liability and inhibit your ability to get your car fixed and to move forward with what you've got to get done. So that's usually the reason why, because they want to get that recorded statement.
And so they're trying to get you to admit something, or what is it that they're usually trying to get from those conversations? Is it a clearer picture?
They are trying to get you. Yeah, well, it can be in some cases, but not typically. It's usually questions, and I know I've said this before, but it's simple questions like, did you see somebody? Did you see the other person driving? How far were you in the intersection at the time when you crossed that intersection? And the truth of the matter is, it doesn't matter whether you just got in the intersection or whether you've traveled 2 or 3 lanes into the intersection. The bottom line is that other car shouldn't have been there, right? And so when you're going through that testimony and you're having to answer those questions, well, did you see the other vehicle? Well, yes, but I didn't think that he was going to, run the red light. Just because I saw him doesn't mean that I thought he was going to run the red light. Things like that will come into play, and how they question it, how they propose the question and your response will typically give them enough wiggle room to kind of convict some negligence on you, or argue it later on in the bodily injury settlement to try to get out of paying that.
You open the door for how they ask the question. I'm kind of curious, what kinds of questions can create a problem later, even if they sound simple at the time and we figure we should just answer them?
Well, for example, we recently just had a case where the client turned around and saw a vehicle in the middle of the road stop. They didn't have their flashers on, but our client was able to stop and then hit the horn because the car was just sitting there, right? Unbeknownst to our client, the crash had just occurred between that car and another car. It was a rear-end collision. So our client stops, lays on the horn, and then just a few seconds later gets plowed into by a Ford F-150 truck. And the guy, there's all kinds of stories about who got hit first and what was going on and, everything that was involved. But the one thing that they remember is the horn, right? And so people assume that because she was blaring on the horn that she was the one unable to stop versus the one that had just gotten angry and stopped and then hit the horn, because why are you in the middle of the road, right? It just makes sense. Like, move, get out of the middle of the road. But in those cases, and luckily our client had the insurance company's app, for the safe drivers, right? Insurance companies will offer, if you install this app, we'll give you a discount on your premium. As a result of that, she had on the app that she was not involved in a collision. Her speed right before the collision was 30 miles an hour. She came to a stop. And those things just really helped prove our case. But again, in that statement, the issue was the horn. Everyone heard the horn, and that meant to them that she's the one that caused the collision, when that wasn't the case.
So even though the information is true, it can be misconstrued. That's what I'm hearing.
Yes.
Why do insurance companies try to have these conversations so early after the accident? Sometimes we're in shock or confused. It saves them money. Yeah.
It really saves them money. It saves them a lot of money. When you look, you can go to the Texas Department of Insurance and they have a complete list of every insurance company and all the data that's involved. And you'll always see the claims that they pay out versus the claims reported and then what they spend on defending those claims. The margins are way off. They don't pay. Their status quo is to deny or place partial fault or to minimize, marginalize whatever they can. And they will spend all of the money they can doing that.
Let's talk about those repeated calls and how they can wear people down or change the way they respond over time. Talk to me about that.
Well, so some insurance companies, everyone's a little bit different, but some insurance companies have call centers that when they get a claim, they will just continue to call. They're not really adjusters. They're kind of something in between. They're just really trying to get the data. Now, the other side of this is that there is a law that requires someone to mitigate their damages. So if the client's vehicle's in a tow yard or it's in some storage facility or, a body shop that may be charging, X amount of dollars per day, those types of things. The client is by law responsible to mitigate their damages. And the insurance company, especially for non-represented people, will really go out of their way to try to inform their insured or their potential claimants that they are responsible for those damages. So a lot of that early onslaught can definitely be information about what they're going to pay and not, and consider reasonable or not. But most of the time, it is usually just to get that statement. They want the statement quick.
Is it okay to not take those calls or must we answer?
That's a trick question. So I'll explain. So if it is the other person's insurance company, right, the one that hit you, then you need to take the call, but you need to take the call with caution and hopefully represented by someone who's going to walk you through the process, prepare you for the statement, be there with the statement is taken to object to any questions that may or may not be pertinent to the claim, right? That may be cited or posed in a way that is giving a misleading or misguided statement of facts, right? However, if your insurance company calls and they want to know about the accident, it's actually in the policy that you have to comply, or they can use the option of what's called reservation of rights. And what that means is that the insurance company will say, yes, you have a valid policy. Yes, you've been paying premiums for your whole life, whatever it may be, but we are not going to you're not going to protect you. We're not going to provide you any benefits. We are not going to engage on the policy because you have not communicated with us in a timely fashion. So yes, they can act on reservation of rights and it's legal all day.
That's shocking to me.
So your participation is necessary in that particular case.
What usually changes once someone stops handling those conversations on their own and they turn it over to an attorney?
Usually there's an assignment change. The adjusters will change. Instead of being maybe the pool of intake people or, the teams, an actual adjuster will be assigned, a licensed adjuster, and that adjuster has been trained to deal with attorneys because it's a different dynamic completely. Usually the attorney is bothered a lot less. The facts and the information, hopefully by a competent attorney's office is communicated effectively with the insurance company to less make marginalize whatever mitigated damages need to be paid. But it is a much different course of conversations, at least in our experience, because the adjuster knows what's going to sell and what's not. The adjuster understands that we hold the potential of filing a lawsuit if there's a disagreement. So they have to be prepared to back up everything that they're deciding on the case.
Can you share an example of a situation where early conversations with an insurance company ended up hurting the case later on?
Yeah, so we had a particular client who gave a recorded statement to the insurance company pretty early on. Actually, it was the same day. And as a result of that, the client provided information about their injuries because they were at the hospital at the time. And so they were like, oh, my knee hurts and I think their shoulder hurt. So the insurance company took that recorded statement, and when we submitted the settlement proposal on behalf of our client, which there was more injuries than just the shoulder and the knee, the insurance company said, "Oh no, we have the testimony of your client the day after the day of the accident when she was in the hospital, and she said these were the only two things that were wrong." But that's not actually, factual because so many things happen after the adrenaline stops pumping, right? And you're sitting there also in
Hmm.
the hospital with pain meds, which doesn't give you an accurate metric on what you're actually feeling. And so we were able to kind of combat that, but it was a little bit difficult moving past our client's own testimony at the time, but right after the accident about what was hurting. Especially when it comes to issues that may have, soft tissues like your neck or back injury, that aren't going to be felt to their potential, probably until a few days afterwards, after the accident.
It's so tricky to know when to talk and who to talk to. Should I talk to the police officer on the scene? He's standing there to do a report. Should I talk to my own insurance investigator or my insurance agent? Um, h- as lay people, do you have some recommendations, some suggestions, some really strong guidance for us to know how to behave in these situations?
Yeah, absolutely. So when you're from the onset, the person that, like you mentioned, the police officer, right? They are going to, even though they act like they're doing their independent investigation, they are going to get a source of information from one source, one person, right? Usually that is the one that is most reserved, quiet, and looks competent, right? Because they want to get a statement of facts. The one that is in a hurry to try to talk to the police officer to get their narrative and all of that is usually the one they avoid. But you'll always see the police officer speaking to usually one person and then getting little bits of information from everybody else. The insurance company wants to do that too. The insurance company, especially if there's a car full of people, maybe there's passengers or whatnot, they want to get the statement from the driver. They don't really care about the statements from the other parties, right? Because usually they're just not as strong, right, about what happened. But when you're talking to somebody, it's best to just be as conservative as possible, as concise as possible, and as factual as possible. Don't draw conclusions because the human mind loves to connect the dots. If this car ran the light, we saw it hit this car. I'm sure they had the red light, but it may have been they had a yellow light and it turned red. It may have been maybe the light's malfunctioning. I mean, there's so many different things that could have occurred. And so, but people will draw those conclusions, if this and that, or causation, and those assumptions or opinions can really hurt a case. But the most reserved and quiet, the most thoughtful and intentional, those are the ones usually that the police and the adjusters want to speak with.
And Paul, let's say that we're moving towards trial. Things are, advancing to that position. How closely do insurance companies compare those early conversations to what gets said later in the case?
Yes, all the time. They love to use it to poke holes at the credibility or character of someone. Because if that story has changed in any dynamic, from the recorded statement to the deposition to the testimony at trial, they will point it out just to hit at the credibility of the client. Especially if it's been a few years since the accident. The jury wants to know, why did your story change? Because you've got my time here. I'm sitting here devoting my time to hear your case, and your story is different.
And then what do people usually not realize about those early phone calls until much later in the case?
They don't realize how much of what they say or the testimony is assumptions. You know, you can say that, to give you an example, we had one case where our client was making a left-hand turn. She had to yield to oncoming traffic to make that turn. Yes, she turned and the other guy hit her, it was a frontal collision and it was very bad. The bus driver that saw the accident from the opposite side of the intersection admitted and testified that our client did not yield and turned right in front of that guy. So yes, what she said was factually correct, and all the testimony gathered at the onset of the claim was correct. But what our client kept saying in that recorded statement was, and to us was, I didn't see him, right? Which most people would assume is, okay, you just made a mistake. You should have been looking. You should have yielded to oncoming traffic. But this accident happened at night, and it just really stuck with me. She kept saying that, and I'm like, was his headlights on? Did he have his headlights on? Because you can't see anything. You can't yield to something you can't see. So we investigated
Mhm.
it further. We issued out a preservation of evidence letter to the insurance company and had an expert go look at the vehicle. And it was an older model vehicle, and the vehicle had no bulbs in the headlights or taillights at all. They were just completely gone. So as a result of
Wow.
that, we were able to kind of overturn the case just based on her testimony. So it was helpful, even though it was all true.
Brilliant thinking and great listening on that one. Paul, here's where I want to end it for today. Uh, we've talked a lot about talk, not talk, some of the stressors that are going to happen after an accident with the phone calls and people wanting to know your story. What's your final piece of advice for folks that are listening today?
I would venture to say if you're going to speak with somebody, the best thing to do is to write it down first. Just go write the story down, get it out on paper, not your head, not with your emotions, not what you feel, but think it through, what you know you saw. And if you need to draw conclusions, which everybody does when they're giving a story or perspective, when you need to draw those conclusions, make sure that you explain why you think that, so that later on, if it ends up being different, you're not proven to be a liar or having misled or misguided the truth in any form or fashion. You're saying, so I feel like he, drove through the intersection or had the red light because this other vehicle started to go at the same time as I did, right? Drawing that conclusion for the adjuster helps explain everything early on, keeps you out of trouble later, but it's most helpful in just to kind of write that all down first. Get it out on paper so that you can see where you need to bridge those things. And that's pretty much the best thing that I could tell people to do early on.
Great idea. Yeah, our memories are good, but they sometimes can be short. Thank you so much for your time today. It was very insightful.
No worries. Thank you, Lisa. I appreciate you.
That's it for today's episode of Advocacy Exchange, Navigating Texas Injury Law. If you've been injured and are dealing with repeated calls from an insurance company, the team at Littleton Law Firm is here to help you understand how to approach those conversations and protect the direction of your case. Visit littletonlawfirm.com to learn more. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.